Hello and welcome to Unit 9 of International Intellectual Property Law. In the last unit, we began our conversations about patent law. We looked at some of the international agreements that covered patent rights, and we began our discussion of patent requirements. In today's unit, we will continue to look at the rights of the inventor, and we will also discuss the so-called North-South debate. Let's begin with a discussion of patent validity requirements. In order for a patent to be valid, it must be novel or new, meaning it is not identical to a prior art. It must be inventive, or as the U.S. law says, non-obvious, which means it should be a non-trivial extension to what is known in the same or similar field of technology. It should have industrial applicability, and it should be enabled, so its description must permit one of ordinary skill in the art to replicate the invention. In order to secure patent rights, an inventor must go to each country's national patent office and receive a registration. Once granted, a patent should last at least 20 years from the date of filing, according to the TRIPS agreement. The TRIPS agreement also indicates a certain scope of protection granted to the inventor. This scope of rights includes the right to exclude all others from making, using, selling, offering for sale, or importing the similar invention within the limited time period. Now let's talk about patent infringement. How is patent infringement determined in each country? Generally, the rules are applied in a similar way. In each case, the patent will need to be interpreted to determine its scope. This will involve claim construction as well as looking at the specifications in the patent document. These claims and the scope of these claims will be measured against the accused device. It will not be relevant that the accused inventor did not know of the patent's existence. And it will also not be relevant that the accused inventor has independently arrived at the same or similar invention. There are two ways that a patent can be infringed. There's the case of literal infringement, which means that every element of every claim in the patent can be read onto the accused device. This means that the inventions are virtually identical. But there's another way that a patent can be infringed, and that's in the case of non-literal infringement. This means that although the accused device is perhaps absent one element of a claim in the patent, it nonetheless will be considered to be an infringement. This is because one element may have been substituted in such a way that the accused invention performs the same function in the same way for the same result. And in that case, that will be determined to be a patent infringement. Therefore, it's very important for a second inventor to understand the scope of the patent and be sure that in the new invention, he or she properly designs around those patent claims. So you can see that the patent right, as compared to the copyright or the trademark right, is an extremely strong right. This is both because the scope of the patent is very broad and entitles the patentee to exclude all others from even making the device, and it's also because these tests for infringement are very broad and cover other inventions which are not identical to the patented invention. The so-called North-South debate refers to a discussion, an international discussion, that concerns the effect of strong intellectual property rights on different kinds of countries. For instance, developed countries seem to benefit more the stronger the intellectual property rights are. And it has been argued that developing countries tend not to benefit at all if intellectual property rights are set too high or too strongly. Why is this? Well, intellectual property rights do have a cost on society. They certainly are intended to provide for benefits to society, such as the promotion of innovation and creativity. But sometimes it is argued that intellectual property rights are too strong and the costs are too much, especially in the case of developing economies. Let's look at some of the possible costs to too strong intellectual property rights. They include concerns about access to knowledge, or A2K, concerns about access to technology, and concerns about access to health or medicines. Recognizing some of these concerns and also recognizing the different place that developed and developing countries were in with regard to intellectual property rights, the WTO in the TRIPS agreement set a different timeline for developed, developing, and least developed countries in order to implement the obligations of TRIPS. For instance, developed countries, such as the United States, had to implement the obligations of TRIPS by January 1st, 1996. Developing countries, such as India, had to implement these obligations by January 1st, 2000. Least developed countries were to implement the obligations by January 1st, 2006. However, this deadline was extended until July 1st, 2013. And then, in the case of patents for pharmaceuticals, it was extended to January 1st, 2016. Let's look in particular at the case of access to medicines. Obviously, pharmaceuticals are a major part of the patent system. These are inventions which require a great deal of research and development. So a lot of cost goes into these inventions, and the patent system is designed to enable inventors to recoup their costs by way of royalties during the period of protection. So the patent system plays an important role in developing new pharmaceuticals. But often the prices for these pharmaceuticals are set so high that few in the developing world can afford them. Sometimes pharmaceutical companies try to set a different price scheme for different areas. Later in this course, we'll discuss parallel importation, and we'll look in particular at how that scheme may benefit this system. But it's important to think about whether the patent system is enabling those who need these medications access to their essential medicines. Let's look at a couple of cases that have involved these questions and see how the intellectual property rights were used in order to sort out this important conflict. The South Africa AIDS drug dispute involved a case known as the Pharmaceutical Manufacturers Association of South Africa and others, 39 pharmaceutical companies, versus the government of South Africa. As a result of the AIDS epidemic in South Africa, that government in 1997 enacted a special law which allowed it to produce patented medicines to treat this disease. This is what's known as a compulsory license, and we'll talk more about this momentarily. In this case, the medicines were duplicated and reasonable compensation was given to the patent owners, although they did not authorize this duplication. As a result of this legislation, a trade association and pharmaceutical companies brought the government to court challenging this new law. As a result of much lobbying around the world, including in the United States, non-governmental organizations intervened in the case as friends of the court and filed briefs, as well as did press conferences in notable media outlets. As a result, the case was dropped. A similar controversy was involved in the Brazil-U.S. WTO dispute. Because 3 million people in Brazil were affected by AIDS, in 1999, the Brazilian government declared an emergency. Because of this emergency, it also created a new law that allowed it, again, to compulsory license any patented AIDS drug. Specifically, what the Brazilian law provided was that if a patent in Brazil was not worked, which meant it was not produced in Brazil, within a 3-year period, the government would then declare a compulsory license. And in the case of AIDS drugs, the Brazilian government provided these drugs free to all residents who needed the drug. As a result of these actions, the United States brought a case against the Brazilian government in the World Trade Organization. And in the last unit of this course, we'll look in particular at that process in the WTO. But again, because of an international outcry against the U.S. and against pharmaceutical companies that were not doing more to help the AIDS pandemic, the United States ultimately withdrew this complaint. Now let's look more closely at compulsory licenses. The TRIPS agreement allows member countries to create legislation permitting compulsory licenses. But there are some conditions on this right. For instance, there's a time limit. That is, compulsory licenses may not be granted before 4 years from the date of the application of the patent or 3 years from the grant of the patent, whichever is later. And in the case where a patent owner has some justifiable excuse for not working the patent, that should be considered by the government. Another condition is that authorization should be sought from the patent owner before a compulsory license is granted. But in the case of a national emergency or some other urgency, this requirement may be waived. The duration of the compulsory license should be tied to the specific reason for its being granted. And finally, the patentee must be given some reasonable compensation for the use of the patent, and that will be determined by the facts in the particular situation. A major event in this debate was the 2001 Doha Declaration on TRIPS and Public Health. The WTO's Doha Declaration was an important moment in the development of international intellectual property laws. It recognized especially least developed countries' need to have proper access to medicines. And the declarations, in many paragraphs, reinforced that public health should be an important goal, as well as the promotion of intellectual property rights. And in order to achieve both, the Doha Declaration recommended helping developing countries use the flexibilities that are within TRIPS to reach these obligations and objectives. The Doha Declaration in particular stressed the opportunity to use compulsory licensing and stressed the least developed countries' opportunities to declare a medical emergency. That concludes our discussion for Unit 9. And in the next unit, we will consider some related issues to patent law, such as traditional knowledge protection and the protection of plant varieties. Thank you for watching.